Welcome to the Deep Dive. Today, we're diving headfirst into something that's surprisingly relevant to all of us. Property law.
Oh, yeah.
Now, I know what you're thinking. Property law sounds
Yeah,
about as exciting as watching paint dry.
right.
But trust me, there's a hidden world of drama and intrigue behind those seemingly dry legal terms.
For sure.
We're talking about the rules that govern everything you own, from your phone to that dream house you're saving up for.
Absolutely. We're going to unpack some fascinating cases and unexpected twists that'll make you see property law in a whole new light.
So let's start with the study guide you sent over.
Okay.
It seems like it's structured around specific learning units, each with its own chapters, kind of like a roadmap. For our deep dive,
Yeah.
what's the first stop on our journey?
The first learning unit focuses on the foundations of property law, setting the stage. For everything else,
Okay.
it kicks off with a chapter that dives into the fundamental concepts of property and things. We'll be exploring what the law actually considers a thing, the difference between negotiable and non-negotiable things, and how even a seemingly simple concept like ownership has layers of complexity.
Okay, so we're laying the groundwork. What are some of the key takeaways we should be looking for in this first chapter?
This chapter is all about understanding the building blocks of property law. You'll need to grasp the distinction between legal subjects and legal objects.
Okay.
Basically, a legal subject is anyone who can have rights and duties. Think of individuals, companies, even governments. A legal object, on the other hand, is something that those rights and duties can relate to.
So I'm a legal subject, and my awesome vintage record collection would be a legal object.
Exactly. Now, within legal objects, we have this fascinating category called things. These are tangible, physical objects. Your record collection fits the bill perfectly. But here's where it gets interesting. Not all things are created equal. In the eyes of the law, we have negotiable things,
Yes.
which can be owned and transferred, like those records you love. And then we have non-negotiable things, which are things that fall outside the realm of private ownership. Things like the air we breathe or the open ocean.
That makes sense. So even though a corpse is a physical object, it wouldn't be considered a thing in this legal sense.
You're catching on quickly. There are all sorts of ethical and moral considerations that place a corpse in a special category. It's not something you can buy, sell, or own, like a basic definitions down.
What's next on our property law syllabus?
The next chapter delves deeper into the concept of ownership. It unpacks the different facets of ownership, the principle of inviolability, and the inherent limitations on ownership.
Hold on. I thought ownership meant you could do whatever you wanted with your property.
That's a common misconception. Yes, ownership is the most comprehensive right a person can have over a thing, but it's not absolute. Think of it like this. You have the right to use your property, to enjoy it, to sell it, even to destroy it. But there are limits.
Okay, so what kind of limits are we talking about? Give me some real-world examples.
Imagine you buy a plot of land in a quiet residential neighborhood. You decide you want to build a factory on it. Seems like it's within your rights as the owner.
Yeah.
Well, not so fast. Zoning laws might restrict industrial development in residential areas. Building codes might dictate the height and size of structures you can build.
Oh,
You might even have neighbors who have a legal right to quiet enjoyment of their property, which could limit your factory's noise levels.
so even though I own my apartment, I can't just blast my music all night or decide to knock down a wall because I feel like it.
Exactly. Your ownership rights are limited by the rights of others and by broader societal interests like safety and public order. And that principle of inviolability we mentioned, it means you can't be stripped of your ownership without your consent. But there are exceptions. Think of eminent domain,
Oh, yeah.
where the government can seize private property for public use as long as they provide just compensation.
Wow. Property law is full of surprises. So we've explored what constitutes a thing in the legal sense and unpacked the complexities of ownership. What else does this first learning unit cover?
The next chapter takes us beyond ownership into the realm of limited real rights. These are rights that someone other than the owner has over a thing.
Okay.
It gets fascinating because we're talking about rights that are attached to the property itself, not just to specific individuals.
Limited real rights. That sounds intriguing. Give me an example.
Think of a right-of-way situation. Let's say your neighbor's property is landlocked, meaning they have no direct access to a public road. They might have a legal right. to cross a portion of your land to reach their own. That's a limited real right, a servitude that burdens your property and benefits theirs.
So even if I sell my property, that right-of-way would still exist. The new owner would have to allow my neighbor to cross.
Exactly. It's a right that runs with the land, so to speak, and it illustrates how property rights can be layered and complex.
This is starting to feel like a legal thriller. What other types of limited real rights are out there?
We'll dive into the specifics later, but some key categories include servitudes, which we just touched on, and real security rights, which are incredibly important in the world of finance, and lending.
Okay, I'm hooked. We've covered the basic building blocks of property law, the concept of things, the nuances of ownership, and even dipped our toes into the fascinating world of limited real rights. What's next on our agenda?
The next learning unit focuses on how ownership is acquired. And it's not as straightforward as you might think. We'll be exploring the concept of original acquisition, where ownership arises without any transfer. From a previous owner, it's a bit like legal magic. Welcome back.
You ready to uncover the mysteries of original acquisition?
It's one of the most fascinating areas of property law.
Absolutely, you had me in legal magic. Let's conjure up some knowledge. What exactly are we talking about? When we say original acquisition, it sounds like something out of Indiana Jones.
Well, it does have a bit of an adventurous feel to it. Original acquisition is all about how ownership arises without any transfer. From a previous owner, we're talking about situations where something becomes yours, not because you bought it or inherited it, but because you took certain actions that, in the eyes of the law, made you the rightful owner.
Okay, I'm intrigued. Give me some examples.
One classic example is appropriation. Imagine you're walking along the beach and you stumble upon a beautiful seashell that's washed ashore. No one else is around, and it's clearly not owned by anyone. You pick it up, admire its intricate patterns, and decide you want to keep it. Congratulations, you've just become the owner of that seashell. Through appropriation.
So it's basically finder-keepers, losers-weepers, but only for things that are truly unowned.
You're on the right track, but there are some important nuances. For appropriation to work, you need both physical control of the thing and the intention to be its owner. Let's say you find that seashell, but you're not really interested in keeping it. You just pick it up to admire it for a moment and then leave it on the beach. In that case, you haven't appropriated it because you didn't intend to. Become the owner.
So intention plays a key role in original acquisition.
Absolutely. It's not just about physical possession. It's about demonstrating your intent to exercise control over the thing. As an owner.
What about things that are abandoned? Let's say I find a perfectly good chair sitting on the curb with a sign that says free. Can I appropriate that?
That's a great example. Abandoned things are considered res nullius, belonging to no one, and are ripe for appropriations. But there's a catch. You have to be sure the owner genuinely intended to give up ownership. Just because someone puts something out with the trash doesn't necessarily mean they've abandoned it. They might just be hoping someone will pick it up and give it a new home.
So it's all about interpreting the owner's intentions.
Precisely. Property law is often a delicate dance of interpreting actions and intentions.
Okay, appropriation is. It's starting to make sense. What other original acquisition methods are out there?
Let's move on to accession. This is where things get really interesting. Accession occurs when an accessory thing becomes legally part of a principal thing. Remember that example we talked about earlier, the tree branches growing over your neighbor's fence.
Right, the branches become part of neighbor's land, and they become the owner.
Exactly. Now accession can get more complex when we bring human actions into the mix. What happens if someone builds on land that doesn't belong to them?
Great question. Like if a contractor mistakenly builds a garage on my property instead of on my neighbor's, who owns the garage in that scenario?
That's a classic property law conundrum. The law had to determine who the rightful owner is. And it's not always a simple answer. Courts would consider factors like the builder's intentions. Did they make an honest mistake? Whether the landowner was aware of the construction and allowed it to continue, and who ultimately benefits from the building.
So it's not always as simple as whoever's land it is, it's theirs.
Not necessarily. Property law loves to keep us on our toes.
Okay, I'm starting to see why property law is a whole field of study. What other original acquisition methods should we explore?
Let's talk about prescription. This one is all about the power of time and possession. It's a way to acquire ownership through prolonged possession of a thing, even if you didn't originally have a legal right to it.
Wait, so if someone openly uses my land for a long enough period acting as if they own it. They could eventually become the legal owner.
That's the gist of it. But there are specific requirements. The possession must be open and uninterrupted, meaning they're not hiding their use of the land. They also need to have the intention of being the owner, not just a temporary user. And the time period required for prescription to kick in can vary depending on the type of property and other factors.
So if I ignore a property issue for too long, I could potentially lose ownership rights.
That's a key takeaway. Property law often rewards vigilance and proactive management of your rights.
This is blowing my mind. Okay, so we've got appropriation, accession, and prescription.
As our original acquisition methods. Is that everything? Those are the main ones covered in your study guide? For this learning unit, we've seen how you can become the owner of a seashell washed ashore, how tree branches can change ownership simply by growing, and how prolonged possession can actually lead to legal ownership. Pretty fascinating stuff.
Absolutely. It's like property law has its own set of rules for creating ownership out of thin air. What's next on our legal adventure?
Well, now that we've explored how ownership arises, it's time to dive into the nitty-gritty of protecting those rights.
Protecting my rights. I'm all ears. This sounds practical.
It is. Let's imagine someone tries to take your property or interfere with your use of it. What can you do? The law provides you with a toolbox of remedies, legal actions you can take to enforce your property rights.
So what kind of remedies are we talking about? Are like calling the police if someone steals my bike?
That's definitely an option, especially if it's a criminal matter. But property law also has its own set of specific remedies that can be used in civil cases.
Give me the legal lowdown.
One of the most powerful remedies is the revindicatio. It's a fancy Latin term, but it's a fundamental principle. In property law, it's the right of an owner to claim back their property from anyone who is unlawfully possessing it.
So if someone walks off with my lawnmower, I can sue them to get it back using the revindicatio.
Exactly. You don't even have to prove they stole it, just that they're possessing it. Without your consent.
That's a pretty strong tool to have in your legal arsenal. What other remedies are there?
Another handy remedy is the interdict. It's a court order that either prevents someone from doing something that would infringe on your property rights or compels them to stop doing something they're already doing that's infringing on your rights.
So if my neighbor keeps parking their car on my lawn, an interdict could stop them.
You got it. It's a way to prevent ongoing harm or interference with your property rights.
Okay. Revindicatio and interdicts. Got it. Anything else?
There's also the spoliation remedy, which can be a lifesaver in certain situations. Think of it as a legal undo button. It helps you get your property back quickly if someone has unlawfully deprived you of possession.
So if someone tows my car from a parking spot I'm legally using, the spoliation remedy could help me get it back quickly?
Exactly. It's a powerful tool for restoring possession even before the courts have fully determined who the rightful owner is.
Okay, I'm starting to feel empowered just knowing about these remedies. It's good to know. I have options. If someone tries to mess with my property rights.
Knowledge is power, especially in the legal realm. But protecting your property rights isn't always about fending off outside threats. Sometimes the complexities arise from sharing ownership with others.
Like when a couple buys a house together.
Exactly. That's where the concept of co-ownership comes into play. It's more common than you might think and has its own set of rules and potential pitfalls.
Co-ownership. I'm sending another deep dive coming on.
You're right. Co-ownership is a fascinating area full of interesting legal scenarios and practical challenges. It's where property law intersects with human relationships and shared responsibilities.
All right, lead the way. I'm ready to unravel the mysteries of co-ownership.
Let's start by understanding the different types of co-ownership, because they each come with their own sets of rules. One common type is called free co-ownership. It's the most flexible form and allows co-owners to dispose of their shares independently.
So if I co-own a vacation cabin with my siblings, I could sell my share to someone else without needing their permission.
Exactly. That's a key characteristic of free co-ownership. Each co-owner has a distinct and separate share that they can do with as they please. Then we have bound co-ownership. This type is less flexible and often arises from specific legal relationships, like marriage, in community of property.
Okay, so if I'm married in community of property, I can't just sell my share of our house without my spouse's consent.
That's right. The law restricts your ability to dispose of your share independently because it's tied to the marital relationship. The underlying idea is that the property is owned jointly and equally by the spouses.
Co-ownership definitely adds another layer of complexity to property law. It makes sense that there would be different rules depending on the relationship. Between the co-owners, what happens when co-owners want to go their separate ways? Can they just divide the property?
That's where the concept of subdivision comes in. Co-owners can agree to divide the property physically, giving each a separate and defined portion.
So if I co-own a farm with my brother, we could subdivide it and each get our own separate plots of land.
Precisely. It's a clean way to end the co-ownership relationship and give each party independent control over their own property.
What happens if they can't agree on how to subdivide the property? Like if one sibling wants the land with the river frontage and the other wants the orchard.
That's where things can get tricky. In those cases, they might have to turn to the courts. For a solution, the court might order a partition sale where the property is sold and the proceeds are divided among the co-owners.
That sounds like a last resort, especially if there's sentimental value attached to the property.
It often is. Courts generally try to encourage co-owners to reach an amicable agreement whenever possible.
All this talk of co-ownership makes me realize how social and relational property law can be. It's not just about bricks and mortar, but also about the connections between people.
You've hit the nail on the head. Property law is deeply intertwined with human relationships, family structures, and even broader social values.
It's fascinating to see how these abstract legal concepts play out in real-world situations.
Absolutely. And speaking of real-world situations, there's one more topic we need to cover that's particularly relevant to South Africa, land reform.
Land reform, I know it's been a major issue here for decades, but I'll admit I'm a bit fuzzy on the legal details.
It's a complex area, for sure. Land reform in South Africa aims to address historical injustices related to land ownership, particularly those stemming from the apartheid era. Your study guide breaks it down into 3 main pillars: restitution, redistribution, and tenure reform.
Okay, let's unpack those pillars. What does each one entail?
Restitution focuses on restoring land rights to individuals or communities who were forcibly removed from their land under apartheid. It's about righting past wrongs and acknowledging the dispossession that many people suffered.
So if my grandparents were forced off their farm during apartheid, they or their descendants could potentially claim restitution to get it back.
Exactly. It's a way to try to heal the wounds of the past and provide a measure of justice to those who were unjustly dispossessed of their land.
What about redistribution?
Redistribution aims to provide land or access to land to people who were historically excluded from land ownership. Due to discriminatory policies, it recognizes that land is a valuable resource for economic empowerment and social development.
So it's not just about righting past wrongs, but also about creating a more equitable distribution of land.
Precisely. It's about giving people who haven't had the opportunity to own land a chance to participate in the agricultural economy, build businesses, and create a better future for themselves and their families.
And what about the third pillar, tenure reform?
Tenure reform is all about strengthening the rights of people who live on land owned by others, like farm workers or tenants. It's about providing security and protection for those who might be vulnerable to eviction or exploitation.
So it's about ensuring that everyone who lives and works on land has a measure of stability and legal recognition.
Exactly. It's about creating a system where people's right to a place to live and work is respected and protected.
Land reform seems like a massive undertaking, both legally and socially.
It is. It's a complex process with many challenges, but it's also a testament to the power of law to shape social change and promote a more just and equitable society.
This whole discussion about land reform highlights the fact that property law isn't just an abstract set of rules. It has real-world consequences and can be used to address social issues and historical injustices.
You're absolutely right. Property law is deeply intertwined with our values, our history, and our vision for the future. It shapes how we interact with the world around us and with each other.
I'm starting to appreciate the depth and complexity of property law. It's much more than just buying and selling houses.
It certainly is. We've covered a lot of ground in this deep dive, from the basic definition of a thing to the intricacies of original acquisition, the power of legal remedies, the challenges of co-ownership, and the significance of land reform. In South Africa, we've even untangled the intricate web of servitudes and real security rights.
My head is spinning, but in a good way. I feel like I've gained a whole new perspective on something I used to take for granted.
That's what the deep dive is all about, unveiling the hidden worlds behind everyday concepts and empowering you with knowledge.
Okay, we've explored the foundations of property law, the different ways to acquire ownership, and even touched on the complexities of co-ownership and the social implications of land reform. What else does your study guide have in store for us?
Well, the next learning unit takes us into the world of limited real rights, where we'll delve into the specifics of servitudes and real security rights, two areas that have a huge impact on how we use and interact with
Servitudes?
and real security rights. Bring it on. I'm ready to unlock another level of property law mastery. You're right, they can get intricate, but they're also incredibly important in shaping how we use and manage property. They're like the hidden threads that connect different properties and individuals, creating a complex web of rights and obligations.
Okay, I'm picturing this legal web now. Let's start with servitudes. What are the key things we need to understand about them?
The Cody Guide breaks down servitudes into two main categories: predial servitudes and personal servitudes. Let's tackle predial servitudes. First, these are rights that benefit a specific piece of land, called the dominant tenement, and burden another piece of land, called the servient tenement.
So it's a relationship between two pieces of land, not just between individuals.
Exactly. The right is attached to the land itself, not just to the current owners. That's why these servitudes run with the land. They continue to exist, even if the property changes hands.
You mentioned the classic example of a right-of-way earlier. Can you walk me through how that works in the context of predial servitudes?
Absolutely. Let's say your neighbor's property is landlocked, no direct access to a public road. To get to their property, they need to cross a portion of your land, if they have a legally recognized right-of-way. That means their property. The dominant tenement benefits from the right to cross your property, the servient tenement.
So even if I sell my property, the new owner would still have to allow my neighbor to cross.
That's right. It's not a personal agreement between you and your neighbor. It's a right that is tied to the land itself.
That makes sense. It's like an invisible pathway etched into the legal fabric.
Of both properties?
What other types of premium servitudes are there?
There are all sorts. You can have servitudes that allow for the drainage of water from one property to another, servitudes that grant the right to draw water from a well on a neighbor's land, even servitudes that restrict building heights or specific types of development to preserve views or sunlight.
So servitudes can be about access, resources, even aesthetics.
Precisely. They're a way for landowners to manage their properties in relation to each other, creating a framework for cooperation and balancing competing interests.
Okay, predial servitudes are starting to become clear. What about personal servitudes? How are those different?
Personal servitudes, as the name suggests, are attached to a specific person, not to a piece of land. One common example is a usufruct.
A usufruct. That sounds a bit like a magical fruit.
It does have a bit of an enchanting ring to it. A usufruct gives someone the right to use and enjoy another person's property and to take its fruits, like crops or rental income.
So if I own an apple orchard and I grant my grandmother a usufruct over it, she could live there, eat the apples, and even sell them for profit.
Exactly. She would have those rights for the duration of the usufruct, which could be for a set period or even for her lifetime, but she wouldn't be the owner of the orchard itself. The ownership would remain with you.
That's a really flexible way to manage property rights. It allows someone to benefit from a property without actually owning it.
You got it. Usufructs are often used in estate planning, allowing someone to provide for loved ones or ensure that a property is cared for while still retaining ultimate ownership.
Okay, I think I've got a handle. On servitudes, they're all about creating specific rights that benefit one person or a piece of land while burdening another. Now let's talk about real security rights. Those sound a bit more serious.
They are serious business. Real security rights are all about securing debts. With property, they give creditors a legal claim to a specific asset, usually property, if the debtor fails to repay the debt.
I was like, when you take out a mortgage To buy a house, the bank has a right to the house. If you don't pay back the loan.
That's a perfect example. A mortgage is a classic. Real security right, it gives the bank a limited real right over your house, ensuring that they can recover their money if you default on your mortgage payments.
That makes sense. It's like a safety net for the lender. What other types of real security rights are there?
We have pledges where you give physical possession of a movable object like a valuable painting or a piece of jewelry to the creditor as security. It's like potting something, but with a legal framework.
So if I need a short-term loan and I pledge
My grandmother's antique diamond ring as collateral.
the lender will...
Hold on to the ring until I repay the loan.
Exactly.
If you don't repay the loan, they have the right to sell the ring to recover their losses.
Okay, pledges seem straightforward. What about those special notarial bonds you mentioned earlier? How did those work?
Special notarial bonds are used to secure debts with specific movable objects, things like vehicles, machinery, or even livestock. They're registered against the debtor's name in a public register, creating a legal claim for the creditor.
So if I'm starting a business and I need a loan for a delivery truck, the lender might require a special notarial bond on the truck as collateral.
Exactly. That way, if you default on the loan, they have a legal claim to the truck and can sell it to recover their money.
Real security rights seem to be all about managing risk in financial transactions. Are there any other quirky ones we should know about?
Oh, absolutely. There are tacit hypothecs, which arise automatically by law in certain situations.
Tacit hypothecs. Those sound a bit...
Sneaky. They're not sneaky, but they are interesting. For example, a landlord has a tacit hypothec over a tenant's belongings that are on the rented property. It's a way to secure the landlord's claim for unpaid rent.
So if I don't pay my rent, my landlord could potentially seize my furniture?
That's a possibility, although there are legal procedures they need to follow. It's meant to protect the landlord's legitimate interests.
Wow. Property law seems to have a remedy for almost every situation.
It does try to cover all the bases. It's a constantly evolving system that tries to balance the rights and interests of all parties involved.
Okay, we've covered a lot of ground today. From those
Fundamental building blocks of property and ownership through the fascinating world of original acquisition to the practicalities of legal remedies, the complexities of co-ownership, and the significance of land reform. In South Africa, we even untangled the intricate web of servitudes and real security rights.
I have to admit, my brain is a bit overloaded, but in a good way. I'm starting to see property law everywhere I look, in my home, in my neighborhood, even in...
Those news stories about land reform, that's the beauty of the deep dive. We take these seemingly abstract concepts and show you how they're woven into the fabric of our daily lives.
So before we wrap things up, is there a little final thought you'd like to leave our listeners with? Something to ponder as they go about their day?
Absolutely. Think about how technology is constantly creating new forms of property, digital assets, intellectual property, even genetic material. These are all things that are becoming increasingly valuable and important in our world. How will property law adapt to protect these new forms of ownership? It's a question that'll keep legal minds buzzing for years to come.
That's a great point, it seems like. The world of property law is only going to get more complex and fascinating.
You're right. The principles we've explored today, ownership, possession, rights, remedies, these are the enduring foundations, but how those principles are applied to new and emerging forms of property, that's where the real excitement lies.
Well, on that note, I think we'll wrap up our deep dive to the world of property law. Thanks for joining us on this journey of legal
Good discovery.
discovery.